Everybody a minute or two more. All right. Welcome back. This afternoon, we'll hear from a final batch of presenters on the issue of fines and fees. We'll hear from staff on issues that we've considered at previous meetings, and we'll also take public comment. The first presenter that we're going to hear from this afternoon is Anita Lee. We're very lucky to be joined by Ms. Lee, the Principal Fiscal Policy Analyst for California Legislative Analyst's Office. Ms. Lee will give us an overview of California's fine and fee system and present recent recommendations made by the LAO. Ms. Lee, it's good to have you. Take it away.
Hopefully you can see my screen. Please let me know if that's not the case.
We can.
Okay, perfect. Thank you so much for having me today. Again, Anita Lee with the Legislative Analyst's Office. As requested, we're going to be providing an overview of the criminal fine and fee system, highlighting recommendations that we've made in the area, as well as highlighting some notable actions that the legislature has taken in recent years. We prepared a handout, which we submitted to the committee, and we'll be using that as a guide for our comments today. And it's the same handout that I'm sharing on my screen currently with you. So if you turn to page 1 of your handout, when we're talking about criminal fines and fees, we're really talking about the amount that trial courts assess on individuals during court proceedings when they're convicted of criminal offenses, which does include traffic violations. If you turn to page 2 of your handout and you look at the table before you, you can see that the total amount owed really consists of a whole range of fines and fees that are added on top of one another. And the courts do have the ability to waive or reduce some of these. Turning to page 3 of the handout, counties, courts, private collection vendors, and the Franchise Tax Board are all involved in the collection of these types of monies. And there are various tools and sanctions that are available for that purpose. Examples of sanctions include the civil assessment, which we'll talk about in a little bit more depth a little bit later, as well as things like wage garnishments. Once fine and fee revenue is collected, state law really dictates a really complex process for the distribution of that revenue to a whole range of state and local funds. And there are particular rules for how those monies need to be credited if payments are not made in full. And so this really requires careful tracking, distribution, and recording of any revenues that come in. Turning to page 4 of your handout, there's an interesting figure that we have on before you. You'll see that the amount that has been distributed has declined from over $2 billion in 2010-11 to about $1.5 billion in 2018-19. About half of the money goes to state government, 42% goes to local government, and the remainder supports collection programs. Turning to page 5 of your handout, our office has really made 2 overarching recommendations to the legislature to improve the system. The first overarching recommendation is for the legislature to reevaluate the wholesale structure of the system. And we provided 4 key questions to guide those deliberations and decisions. The first question is, what should be the goals of the system? For example, deterring behavior or mitigating the negative effects of crime, but that really should be used to then set fines and fees. And the second question is, should ability to pay be incorporated? And if so, how? An example of that could be setting the actual amount owed based on a person's ability to pay. But another option would be to set the same amount, but authorize different ways to basically address the amount that's assessed. The third question is, what should be the consequences for failing to pay? And related to that, what can we do to help individuals avoid having to face those consequences and kind of staying current on their obligations? And the fourth question is, should fines and fees be adjusted on an ongoing basis? And if so, how and in what manner? Our second overarching recommendation was for the legislature to increase their control of criminal fine and fee expenditures. And this really had four components. The first component was to deposit most of this revenue into the general fund and then just appropriate funds to support programs based on their actual need rather than being disproportionately impacted by the revenues that were coming in. The second component was to consolidate most of the fines and fees into a single statewide charge so that it would be really clear what was the consequence for a criminal offense, but it would also eliminate all of the administrative burden for tracking and distributing those revenues. The third component would be to reevaluate all of the existing programs supported by this type of revenue to ensure that it was still a legislative priority and to make sure that they had the level of resources needed to meet desired service levels. And then the fourth component was that the legislature will want to make sure that any changes that are made would mitigate impacts on local governments. And so of particular note, counties often use their share of this type of revenue to help meet their required payments to the state to support trial court operations. Turning to page 7 of the handout, we wanted to flag for the committee that, as noted on the figure, revenues have been declining, and the state really has had to take actions to address that declining fine and fee revenue. And it's really been done in 3 key ways. There have been shifts of costs, expenditure reductions, and increases in revenue. A notable kind of cost shift is that a number of programs have been shifted to be supported entirely by the general fund, or the general fund is actually providing backfills to particular funds to maintain expenditure levels. Turning to page 9 of your handout, 8 of your handout, the legislature has also taken a number of notable actions to reduce impacts of fines and fees on people. And a key example of that is that the legislature has eliminated certain assessments. At the top of the page, you'll see that in 2024-25, if there is sufficient general fund revenues to backfill the revenue loss, restitution fines would be eliminated. Kind of moving down the page, under state law, the authority for the emergency medical air transportation penalty assessment has actually expired. And at the very bottom of the page, as part of the 2020-21 budget package and the 2021-22 budget package, about 37 criminal justice and administrative fees have been eliminated. And the state's providing currently a total of about $125 million annually to help backfill that lost revenue. And that's going to predominantly counties, but a small portion of that is also going to the judicial branch. Turning to the final page of your handout, there are a few other notable actions that we wanted to highlight for the committee. The legislature has taken particular interest in reducing sanctions. As mentioned, is the civil assessment. So as part of the 2022 budget package, kind of consistent with our recommendations, civil assessment revenues are now going to be deposited into the general fund rather than a judicial branch special fund. This is an assessment that's applied when individuals fail to pay or fail to appear. But the focus really here is on kind of failing to pay. And so it also changed state law to reduce the maximum amount that could be charged from $300 to $100. And so the state's also providing an ongoing $67 million general fund backfill to maintain service levels. Similarly, civil assessments owed prior to July of 2022 are waived, and a one-time $10 million backfill is going to be provided. The legislature has also eliminated collection programs' abilities to use driver's licenses holds and suspensions as a collection sanction. And last but not least, you're going to be hearing from your next presenter, but to kind of tee it up, as part of the 2022-23 budget, the legislature authorized the statewide use of an online adjudication tool for infractions and required that all courts offer the ability to pay component of the tool by June of 2024. And the state's also committed to providing about $28.4 million annually to address that revenue loss. And so I'm going to conclude my comments there in the interest of time. I'm happy to address the committee's questions at the appropriate moment. Thank you.
So thank you, Ms. Lee. I just want to make a couple of clarification points. First of all, you said that the amount of money collected roughly, and I know it was a couple of years ago, but it's about $1.5 billion. Is that correct?
Yes.
And that includes traffic violations.
Yes, and so it does include traffic violations. It doesn't include parking. I get that question a lot, so I thought I would flag that for you.
Do we know what percentage of the 1.5 billion is traffic?
No, so the money kind of comes in sort of all together. I will say that in conversations with the judicial branch and kind of the way that the data comes in, quite a bit of it will be related to traffic infractions or misdemeanors. And the reason why is individuals that are convicted of felonies will frequently have restitution orders, and restitution orders are going to be the highest priority in terms of the obligation being met, and so wouldn't be captured as part of it.
So traffic infractions and misdemeanors, but other than traffic. I just wanted to make sure that we're saying.
Yeah, so this includes all.
No, I understand. I just wanted to understand your point. All right. And then finally, and maybe this is a question to Rick, I believe in the memo, you said it's about $1 billion, not 1.5 billion. I don't know if it really matters for our purposes, but is there an important distinction that we're missing there that
I don't know. I think I was referring to the most recent judicial council report on court ordered debt. Obviously, I don't know if there's a different.
Sure. Yeah, there's a little bit of a difference. The judicial branch report is one of the sources that we pull from, and the report that they focus on is kind of based on data that's reported to them. We also pull from other sources, specifically the state controller's office when we're sort of looking at this data. That's one aspect. And we do look at kind of other pieces if we can pull that in as well. Part of the issue is there's quite a lack of data on maybe some of the amounts that are going to locals. And so we do try and do calculations to make our best estimate for what that can look like. And so that's really kind of the difference related to that.
All right, but I want to make sure we're talking about the same thing here, right? We're not talking about different pots. We're just, all right.
Yes.
All right, excellent. Super helpful. I really appreciate it. Anybody have any questions? Ms. Lee, as I've asked our other presenters, if you do have time to stay with us for our panel, it might be helpful to have you chime in. If not, we haven't booked you, we haven't reserved you for that time, so you add it to our bill.
Absolutely. I'm happy to stick around.
Okay. No fines though, please. Our next presentation is from Francine Byrne. Am I pronouncing your name correctly?
Yes, that's correct.
Okay. Ms. Byrne is the Director of Criminal Justice Services for Judicial Council's Operations and Programs Division. Ms. Byrne will share findings from Judicial Council's recent evaluation of online ability to pay determinations in infraction cases. Ms. Byrne, please take us away.
Great. Thanks. Can everyone hear me all right?
Yes, we can see you live.
Thank you, Ms. Lee, for queuing that up so well. So I'm the director. I'm Francine Byrne, Director of Criminal Justice Services. I also have on the line Martha Wright, who manages this project and has from the beginning, can answer questions. I want to give a shout out to Dr. Colin Christensen, who did most of the heavy lifting and data collection for this report. So I'm going to give you a little bit of the background of the context with which we started this project. I'll explain the project a tiny bit, and then I'll provide some preliminary data, some things fresh off the press from just a few weeks ago of some findings that we're getting from the ability to pay project. So this was, as you all know, and as Ms. Lee walked through very well, there's a lot of issues related to fines and fees and this disparate impact on people of low income. So in 2026, the U.S. Department of Justice launched the Price of Justice Grant to investigate the appropriate role and limits of fines and fees in the justice system. California was one of 5 courts awarded the grant, and one of the things we were able to do with it was develop this online tool to allow people to request ability to pay determinations. Then the state stepped in, as you've heard, and developed a pilot project for us to test the tool in 7 counties. And then we are now, with further support, in the middle of the statewide launch of the tool. We're up to 28 counties now and are in the process of onboarding the rest of them in the next year or so. So you all may remember that it wasn't that long ago that litigants really only had 2 options when they had traffic adjudication cases. They could either pay their fines in full or they could go to court to try to get some sort of reduction, or in many cases, they tended to have to do both. So with a number of changes in legislation as well as this project, things have changed a little bit. So now we have this tool, it's an online tool, as I mentioned. It's interactive, very user-friendly. People get on it and they can request determinations and punch in some basic information, and that information will go directly to the court that can make that determination for a reduction. It is completely online. It's available in English and Spanish, and we do have some plans to make it into additional languages as well. So who's using the tool? Right now, these are the demographics. It's largely the folks that have used it so far is largely Latinx, about 46%. We have about 26% white, 9% Asian, 8% Black. We know this isn't exactly the demographics of California. It's a little bit closer to the demographics that you would see in the pilot counties and more so in kind of the traffic area. But the beauty of this project is that we actually have data now that can show this, and we can use the data to know if we need to do additional outreach or test it in other areas. The other things we know then, of course, is that the people who are requesting these things are low income, 88% or at or below the federal poverty level, or 250% of the federal poverty level, that is, and more than half are already on some form of public benefits. So we have a number of different, well, let me first.
I'm sorry, did you say more than half a second ago?
Yes, so about 54% are on some sort of public benefit.
I think I could have read the chart wrong, but it looked like it said the opposite.
Sorry. Oh, I'm sorry, less than half, slightly less than half. I apologize. Yes, 46%. 54 are not on benefits as of yet. We don't know that much about why or of that. So as of June 15th, 28 courts are now using the tool. They have processed over 87,000 requests that represent more than 60,000 individual litigants. The average amount that's been initially owed at the beginning of this is a little under 500. Prior to the passage of AB 199, which capped civil assessments at no more than $100, that number was 671. So far, there's been about $26 million forgiven based on the use of this tool, and the average amount reduced per citation is about 59%. So when we're looking at sort of whether or not the tool is a success, we looked at two performance indicators. One is whether or not it increased access to these court services of asking for these ability to pay determinations, and also whether or not it reduced the fines and fees to an amount that the litigants were actually more likely to successfully and fully pay. So the first one is looking at the request. So it does look like the number of overall ability to pay determinations requests have gone up quite a bit. There's still a number of people using paper files. That will always happen. We don't want to change that. It has gone down a bit since we started the My Citation project, but it hasn't gone down. It's sort of leveled off, and you can see here from this graph that the number of online determinations that have been requested has sort of skyrocketed in the last year since we've obviously launched the tool. And then looking at the success rate. So this is not anything that will probably come as any sort of surprise, but what we're finding is that the higher the amount ordered of court debt, the lower the chances are of actually getting full repayment. We measured success by whether or not the person had fully paid the debt by the time it was due by the court. And we're seeing it's somewhat, and I think the data is getting closer and closer to kind of a sweet spot, but it looks like your amount that you'll actually be recovering or being able to collect really dips down below 50%, right around the $300 mark. As we gather more and more data, we'll be able to say more and more about what that might look like. And you see a similar findings for payment plans. Many of the courts put people on payment plans of roughly $25 a month, seems to be average. And of course, the longer those payment plans go out, and therefore the longer the amount ordered, the higher the amount ordered, the less successful we are in gathering the actual, gathering the funds. And again, we see an amount somewhere probably around the $200 or $300 range that we get to about that 50% success rate in gathering it. So what are we doing next? This is sort of our next step is, again, launching in the remaining courts that have not yet implemented the tool. And we also want to look into doing a little more outreach. So we are pretty well covered in the courts. We have Post-its, notes, and posters, and have a lot of information about this once you reach the court. But again, the point is sort of to get those people prior to even going to court, where they have to take time off work, et cetera. So we are interested in sort of getting the word out there more and starting to partner with other folks who might be dealing with these litigants that could help them out, let them know that outstanding cases can also be sometimes go through this process. We're also working with courts to improve communications about notices when they have these infractions and traffic violations, and using more clear and user-friendly language in order to communicate the fact that the tool is out there, that they can request it, and so they understand what their obligations are. We also are, not as part of this project, but a separate project, actually working on updating the traffic citation ticket itself to also make that user-friendly and a little bit more helpful for the person who actually receives the ticket to understand what their obligations are in the next step. And with that, that was just a little taste. I made it as short as possible. If there's any questions, I'd be happy to take them now.
Thank you very much. Can we stop the share for a sec?
Sure.
Thank you. Same line of questions as I asked Ms. Lee. This includes traffic tickets and what we'll call court criminal conviction fine. What's even the nomenclature differentiating traffic fines and fees from the rest of fines and fees?
So it's all infractions, and it's mixed. It's about 96% though are traffic. So the other so it's infractions, it's not misdemeanors, so it's the lower level cases, and the vast majority are traffic.
So my citations does not apply to court ordered fines and fees with an ordinary criminal conviction.
Not at this time.
But it conceivably could.
Yeah.
All right.
The mechanics are there.
So it sounds like it's really designed for traffic infractions.
It is at this point, yes.
Yeah. Cool. Really interesting.
I wonder, Ms. Byrne, if some of the findings that people ordered to pay less actually pay more, considering that these findings are related to people ordered to pay traffic infractions. Do you think that that has any relevance to people ordered to pay fines and fees in misdemeanors and felonies? What's the relation there?
I see Martha jumped in. I'm not sure we know yet. Martha, if you have other things, if you want to add to that, but we don't really have that information yet.
Yeah, I think the process is just very different. Paying a traffic ticket, if you will, is essentially just about that one infraction, that violation. The way fines and fees come together and what people owe for other case types, I think, is just so different in the way that's imposed. And the process that you go through in order to know what you have to pay and when and to whom is really different. But that's not to say that we're not learning from what we're seeing in infraction cases. It just seemed like the logical place to start, and also a super high volume place to start.
Remember, Brian?
Yeah, I've got a question for kind of the LAO, and that there may not be, well, two questions. One for my citations. It seemed like those demographics, by and large matched kind of California, but does that match the pool of people who are getting traffic citations? I'm just kind of wondering how that parity with the state's demographics was so spot on, but not maybe necessarily with the pool of people who come into contact with.
That's that's sort of why I brought it up. We don't know yet. We're still not statewide. It is something that we sort of noted, and very, very happy that we actually have a rich data set that we haven't had access to. But we don't have the answers yet. But again, the nice thing is we still have this ongoing data, and it's one of the things we'll look into.
Awesome. And then for the LAO, you mentioned a lot of revenue, or like revenues are down. And so the general fund is backfilling for some of these things. And I'm just curious, one of the things I found effective in the legislator the last couple of years, are there any of these fines that are assessed that we actually spend more money trying to collect it than we end up collecting? That the likelihood of recovering anything for certain types of citations is so low that waiving them or discharging them actually saves us money?
Yeah, no, that's a really, really good question. So our office actually, before we looked at the criminal fine and fee system, we actually had an earlier report that looked at the court order debt collection process entirely. And so the point that you brought up is something that we flagged at that time in terms of, at that time, and I want to be clear on this distinction, at that time, we had significant concerns about how the system was actually set up in a manner that we were not necessarily rewarding behavior in kind of key ways. One, from the state perspective, where you were getting bang for your buck. You were going after things where it's actually getting pretty close, if not exceeding what you would bring back in. That was sort of one. But also related to that was that there was actually greater incentive based on the way state law was set up to collect when things were delinquent, because programs can cost recover for those activities. They couldn't do the same thing for non-delinquent activities, which we found was like, one, that might be cheaper, but two, for the user was also better. Like if you were a person who wanted, who wanted to comply and pay, there were things that you can do like monthly billing slips, like think about your utility bill, that would actually help you keep on track and you wouldn't go delinquent and you wouldn't suffer from any of those penalties. And they didn't really have incentive to do that. So that's kind of one thing. In relation to that, over time, I do want to give the judicial branch credit. The judicial branch, our office with the legislature, we've been having discussions sort of related to that. And the judicial branch, in working with counties as well, has taken broader efforts to start discharging debt and kind of thinking about what is actually collectible and kind of honing in efforts more. I would say, speaking on my behalf, not necessarily on the judicial branch's behalf, I think that there's certainly more efforts that can go into that arena. And there are certainly more improvements that could occur. But over time, in recent years, some efforts have been put into that. And so hopefully that addresses your question.
I just want to piggyback on that real quick, and the answer might be we don't know, but sounds like the estimate is around $1.5 billion in fines and fees total. Do we have any estimate on the total costs in recovering that money?
So what we have, and Francine will chime in. So the judicial branch is kind of the key repository of the data, and they are required to report to the legislature. And so counties and courts by county, because as I mentioned, there are various collection partners involved. They're reporting to the state in terms of how much they're collecting and how much it's costing them, at least based on what they can see. That's a little bit different from the collectability question. And on collectability, sometimes you often have to hire an expert to kind of.
I'm just asking on the cost. Do we have an estimate on how much it costs to collect?
So in that chart that I showed you in the handout, that 7%, so our data goes through 2018-19. That's actually, and I apologize, related to your earlier question about Rick, why the numbers are different. The years we're also looking at are different. But that it's about 7 or 8% of that. When I mentioned that was going to collection programs, that's how much it's costing for delinquent debt collection. That doesn't cover non-delinquent because that's not reported.
So we don't know. It's much more than 7%, I presume, the whole infrastructure of collecting all this money.
Correct.
The short answer is we have no idea.
Correct.
All right. Got it. Super helpful. As with our other guests, no good deed goes unpunished. If you could stay, we'd love to have you. With that, our next panelist or our next presenter is from Washington State. Washington Assembly Member Simmons, you have it. Is that your representative? Excuse me. So we've already invoked Washington today. So thank you for joining us. We're joined by Washington State Representative Tara Simmons. Ms. Simmons will share about her own history with court-ordered debt and the work she's done to eliminate mandatory fines and fees in Washington State. As I said earlier, I am a proud former Washingtonian from Seattle. It's good to have you. So please take it away. We'd love to hear from you.
Yeah, thank you so much for having me today. I am Representative Tara Simmons from the 23rd Legislative District in Washington State. I am also an attorney and I'm a former nurse and a mother. But for most of my life, I cycled in and out of the juvenile justice system and jails and prisons. I actually lived in Stockton, California, where I was raised by my father, and we lived in really rough neighborhood, and I was exposed to violence at a very young age. My father actually got his GED from the California Youth Authority. So I'm just highlighting that this is intergenerational trauma and violence that I have survived, and what led to my substance use disorder later in my life, and subsequently incarceration. I got out of prison 10 years ago. And I realized that I was not going to be able to find a job or a place to live. And I had these court fines and fees. I was working at Burger King, and they were garnishing my paycheck to pay off my court fines and fees. We call them legal financial obligations here in Washington. They're LFOs for short. And so, you know, making such a little amount of money, and they're garnishing it to pay those LFOs. I couldn't afford housing for my children, who I was fortunate enough to reunite with when I got out of prison. And I really, you know, started to think, you know, this is why people recidivate. This is why people go back to underground economy, crime. I started thinking about, you know, maybe I could just sell drugs and not use them. And this is while I was going to my Narcotics Anonymous meetings and trying to maintain my recovery. And I realized that there was no way out of this complex web, because I couldn't get a job that was meaningful because of the criminal record. But I couldn't afford, you know, housing or anything. So I decided to go to law school to figure out how to change the system. I didn't never know a lawyer outside of my public defender. And I really didn't like them very much, but you know, and so I went to law school on a whim and hope, and just had read a book of a man named Sean Hopwood, who graduated from law school, or he was in law school at the time, but he had done 12 years in federal prison for 5 armed bank robberies, and he was a second-year law student. So I read his book, and then I went and met him because he was here in Washington, and he inspired me. I went to law school. I graduated magna cum laude. I founded a nonprofit organization, and I served on several boards and commissions, and I did a lot of advocacy on LFOs and used my story to share with judges and lawmakers how these LFOs kept me in a cycle of poverty and incarceration, and how I was trying to fix it. So during my time before I became a lawyer, I had helped change one law here in Washington that removed the 12% interest that was accruing the whole time I was in prison. And I spoke at a judicial conference, and a judge found out about my story and sent a check to the clerk and paid off my $5,000 of LFOs and helped relieve me from that. But, you know, I was very lucky. You know, that was just like hitting the lotto. That's not a sustainable model for people. And so I graduated law school, and even though Sean Hopwood had got admitted 2 years before me, they wouldn't let me take the bar exam because of my past criminal history. And I appealed that to the Supreme Court and won in a unanimous same-day decision, and became a lawyer in 2018. And then I ran for office, and I became the first formerly incarcerated legislator, we believe, in the nation in 2020. And now there's 5 of us across the nation. And so my, you know, work has really been led by my lived experience and trying to make sure that other people don't have to go through these insurmountable barriers, because I really care about victims as well. I was a victim long before I was ever a defendant. Growing up in Stockton, California, I was trafficked at 12 years old, 13 years old. I've survived so much violence, and I really want to keep communities safe. And so I really think that when people come out of prison and they're facing all of these barriers, they are being pushed to go back to what they know. They can't live with the stress, but also practically, they can't live without any money. And so I have been a part of 3 bills now to incrementally reform our LFO system in Washington. One is when I was an advocate and started that nonprofit, which was just a dream. And now I have 16 staff members, and most of us are formerly incarcerated. And we're helping people, taking individual cases to remove their LFOs, and then doing advocacy as well. And then a lot of other collateral consequences as well. But so the first bill was to remove the 12% interest on mandatory LFOs and get rid of a bunch of discretionary costs that we were charging people, like their public defense costs and the county clerk money and the law enforcement money and things like that. And then my first session in 2021, I introduced House Bill 1412, and it passed in 2022. And that bill helped look at restitution if it's insured loss. So if it's to an insurance company or if it's to a state agency. Now a judge has the ability to reduce that interest that has always been 12% and waive the principal if a person can never pay it off and an insurance company paid it. So we got that through. And then this last session with House Bill 1169 that goes into effect here next month, we finally got rid of all mandatory LFOs. So if you are poor and you don't have a victim that has restitution that you owe, you don't pay anything anymore when you're convicted of a crime. So the two last mandatories here in Washington, one was to fund the victim penalty assessment. And what that does, that fund pays for a victim advocate in the prosecutor's office. And I got a state backfill to fund that service. So the state is now paying for the victim advocates that are in the prosecutor's office instead of trying to collect it on poor people. And then the other one was the DNA collection fee. So every time someone's convicted of a felony, they have to have their DNA taken, and it was $100 fee. And the state's paying for that now too. And what this was had broad support, bipartisan support, also the clerks, the prosecutors. There was no opposition, victims, everybody came together to say this is the best way forward. And it really helped the clerks in the system because they were spending dollars to chase dimes. And so I see my time is up, so I will stop.
Thank you very much. I just wanted to clarify lots of things. It's good to meet you, and thank you for joining us, sharing your story and your successes. I know Sean, so I'm always glad to hear this story inspires people. You're saying that there are no more fines and fees at all, or there are no more mandatory ones?
No more mandatory ones. So if you have money, if you're wealthy, a judge can impose discretionary costs on you and have you pay for, lab fees and all the things, but there's no more mandatories. So if you're indigent, and there's the indigency standard. So if you're receiving public benefits, if you have a public defender, you're not getting any LFOs here in Washington.
So if you have, let's just make it clean cut for our purposes. If you have a public defender, 0 fines and fees?
Yes. Unless it's restitution to a victim.
And then there's that restitution reform, let's call it, about the insurance that you were discussing before.
Well, yeah, if an insurance company paid it, then you can ask the judge, and the judge it's discretionary though. The judge doesn't have to, but a judge can waive the principal or the interest or both.
Thank you. Assemblymember Bryan.
Ms. Simmons, you are a badass. And thank you for your story, for your lived experience, for sharing it with us. I was camera off, but I was listening to every second of it. Just wanted to drop a comment that I'm incredibly inspired by the work that you're doing. Going to read more about it and see what can be applicable here in California. But just thank you for all you do and for being where you are. I'm grateful to share this space with you today.
Thank you. Likewise.
Here. Other comments or questions from the committee or panel or staff before we move on to the panel? And Representative Simmons, if you can hang on with us, we'd love to have you as we continue the conversation.
Okay.
But is any specific questions for Ms. Simmons before we go on?
I wonder, well, I just want to join the chorus. Thank you so much for being with us here today. In the 5 minutes we give, we often don't get the full story, but I wonder what led up to passing these bills. I imagine it wasn't something you thought of and then a month later it got through and no problem. What sort of work preceded it, or what sort of helped make the case with your colleagues?
Yeah, so when I graduated from law school, I got a Skadden fellowship, and my Skadden fellowship was around reentry barriers. And I've been doing this advocacy work for years while I was in law school. So I've been out 10 years now, and I probably started advocacy 9 years ago. And so I've been involved in just a lot of, employment barriers, voting rights, everything to kind of free my people. And so I was really primed when I joined the legislature. I had so many ideas. I still do. I've passed 11 bills in 3 sessions, but I still have like lots that I want to do. And then also I've just been investing in other formerly incarcerated people as well to teach them advocacy. So it's not just me. And that's what my organization does, is around equipping people with lived experience to know how to share their stories, but also learn legislative strategy and partner with other organizations and build coalitions. So that's how we've been able to kind of lay the groundwork here in Washington. And I know a lot of people in California who are doing this work, and I'm connected to them through national organizations. So you guys have the ingredients there in California.
In terms of the ingredients, my understanding is that in Washington state, there's like a more robust data regarding criminal justice, LFOs, and that was there some a research component, a data component showing kind of maybe different from California, where we kind of have traffic, misdemeanors, and felonies all lumped in? I think maybe in Washington there was more of a data component. Is that something you can speak to?
Yeah, I mean, the data here still is not really great, and we don't have a unified court system. And so we run into challenges with implementing certain reforms, like we're not able to do clean slate, and you all have been able to do that. But I know that we were able to disaggregate the data enough to make the case. And we did partner with researchers, Dr. Alexis Harris, who wrote the book, A Pound of Flesh, here in Washington, and she's worked in several states. And so if you're looking for help with research, she might be a good contact. Also, Justice Action Network and Arnold Ventures nationally are doing fines and fees work, who, they're researchers too. So they're good contacts as well.
And this is my recurring question to everybody, just to make sure. I'm assuming that the work that we're discussing in Washington does not include traffic fines and fees, traffic citations, or does it?
No, this is criminal convictions.
Got it. All right.
Mm-hmm.
Any additional questions? Great. All right. Representative Simmons, if you could stay, that would be terrific. We're going to introduce three more panelists to continue our conversation and hopefully hone in on some recommendations for California. Our final panel will continue a discussion of fines and fees. Our panelists are Lisa Foster, who's the Director of Fines and Fees, the Fines and Fees Justice Center. Am I missing Ms. Foster? Oh, okay, can we keep on going?
They're coming up. The Zoom is being a little slow, but everybody.
I see you now, Ms. Foster. How are you? Welcome. Brian Sykes, Associate Professor of Criminology at UC Irvine. Professor Sykes. And Leon Dixon, Managing Attorney and Acting Regional Counsel for Legal Services of Northern California. Thank you for joining us. Judge Foster, where are you on my screen?
Looks like we just actually did lose her, so I'm sure she'll be right back.
Professor Sykes, can we start with you?
Absolutely. So I want to discuss a paper that one of my longtime collaborators and I just recently published on Beyond the Penal Code, which is about monetary sanctions in the corpus of California law. And this paper was published with Anjali Verma, who's an assistant professor at UC Santa Cruz. And so, as I'm sure you all know, monetary sanctions tend to constitute fines, fees, court costs, penalty assessment, restitution, interest, and all these other sort of special funds that get imposed at the time of sentencing or during a plea deal. They also go by the name of legal financial obligations, and the use of these monetary sanctions in the criminal legal system has increased over time. This criminal legal system debt, as we just heard from the previous panelists, creates barriers to economic self-sufficiency, and they compound pre-existing socioeconomic inequalities, including racial disparities and selective enforcement of criminal law. these monetary sanctions also represent an expressive element of sociocultural punishment that implicates the social and institutional processes that produce and sustain racial and ethnic distinctions through rituals and cultural scripts of criminal sanctioning in the United States. So there's a lot known about monetary sanctions, and there are a number of conjectures about monetary sanctions. And one of those conjectures is that monetary sanctions are generally restricted to criminal or penal codes. And so in this paper with Professor Verma, she and I showed that in California, monetary sanctions are embedded in both criminal and civil legislative code sections and statutes, which requires a sort of deeper excavation and enumeration of the legislative statutes that govern and impose monetary sanctions in California law. And so to get a sense of what we're trying to the argument that we're trying to make, we argue that the legal capacity in order to that sets the framework for understanding racial disparities begins with the bifurcation of criminal and civil law. But then there are also civil criminal and criminal civil hybridities that have emerged depending on whether or not you have a criminal case that can lead to a civil case and whether or not you have a civil case that can lead to criminal charges. And once whatever the legal proceeding is that takes place, it happens because there's some sort of selective activation by state agencies and local police, and that disparate application of these laws are what produces and sustains these racial disparities. So in our work, what we did was we went through and read every statute in the legislative and the California Legislative Code. And with a team of 6 undergraduate researchers, each researcher read the same statute at least twice. And what we found was out of the total of 165,000 statutes in the legislative code, over 7,000 of them had some sort of monetary sanction, representing 1 out of 25 statutes in our legislative code. Now, though how that 1 out of 25 is distributed is unequal. They're disproportionately concentrated in the penal code, where the relative prevalence of monetary sanctions constitutes almost 19%. However, the vast majority of all monetary sanctions are in other legislative code sections. And so by only focusing on the penal code, we ignore other sources for stratification and inequality by race. And to get a sense of this, we turn to the very report that this committee produced in 2021 on racial disparities and arrests for driving on a suspended license. And here, that's an established social fact that's largely triggered by local police. And of course, these are generally criminal misdemeanor cases. But as you can see, there are 3 different, three different code sections, legislative code sections that are implicated: the penal code, the government code, and the vehicle code. And when you do this legal census that we argue that needs to be done, where you look at every legislative code section for monetary sanctions, what we saw was really astounding. So we coded each statute for 31 different attributes of monetary sanctions across the California's 29 legislative code sections. And for each code section, the relative percent of those statutes that have monetary sanctions, as you approach 100% on this heat map, you see that it goes from 0 light shaded to yellow, all the way up to 100% or orange. And so this first column shows you that across 31 different attributes of monetary sanctions within the penal code, fines and fees, and those fines and fees that impose a maximum and some minimum LFOs they dominate, right? As well as the use of incarceration as an LFO payment. But what was surprising and unexpected for us was the fact that if you look at the other 28 legislative code sections, they don't look all that dissimilar from the penal code. And so it's our hope that this committee can take up these issues beyond the penal code, because failure to excavate and enumerate the entire legislative corpus of a state can conceal racial and spatial and economic inequality in these financial punishments. Thank you.
Thank you very much. Okay, we're back. Thank you very much. That was super interesting and helpful. Judge Foster, are you back with us?
I am. I don't know.
It wasn't part of your introduction, so it's good to meet you. I'm glad to have you back. If you could give us a few minutes, and then we'll get to questions and answers.
Sure. Again, I'm Lisa Foster. I am the co-founder and co-executive director of Fines and Fees Justice Center, which is the only national organization focused exclusively on fines and fees in the American criminal justice system. I am also a native Californian and a retired California Superior Court judge. It's a pleasure to be here, and I am thrilled.
May I ask where you were a judge?
San Diego.
I've heard of it.
I'm really thrilled that you all are considering fines and fees in your work on the penal code. Generally, when I talk about fines and fees, I talk a lot about the harms that fines and fees impose on individuals, families, and communities. But I can't do that any better than Representative Simmons did. And so that, and the fact that I want to focus today on the penal code, and in particular, why fines and fees are at odds with the penal code and often undermine the goals of the penal code. I want to leave you today with 3 key points. First, a penal code is not and should not be a tax code. But that, in fact, is what California's penal code is in part today. Second, except in limited and carefully defined circumstances, fines should only be imposed as an alternative to a sentence of incarceration, not in addition to a term of custody. Third, if and before a fine is imposed, courts must do an ability to pay assessment, and mandatory minimum fines should be eliminated. Let me explain each of these in turn. The US Supreme Court has defined a tax as, quote, an enforced contribution to provide for support of the government. And that is precisely what several penal code sections do. The penalty assessment, the state criminal surcharge, the court operations assessment, those all exist for the sole purpose of raising revenue. They are taxes. The criminal surcharge goes straight to the general fund. The penalty assessment funds numerous California programs and services, including the Department of Fish and Wildlife, the Office of Emergency Services, a traumatic brain injury fund, prosecutor and public defender training. The court operations assessment goes to the Judicial Council. And because I know it's going to be asked, all 3 of those are imposed on traffic, misdemeanor, and felony convictions. All of those are important government programs and services, and all are supposed to serve all Californians. They should be paid for by all Californians. And one has to ask, why are the people convicted of traffic, misdemeanor, and felony offenses required to pay more for those services than any other Californian? And more to the point, and to the point of this committee, what is the possible peniological purpose of imposing these assessments and surcharges? What point do they serve when we think about why we are imposing a sanction on people for violating the law? I also want to focus on what California calls its restitution fine, but is truly a fee. And that is imposed only on misdemeanors and felonies. Now, why do I say it's a fee? Well, first, if we go back, the restitution fine goes to the state restitution fund, but so does a percentage of that a penalty assessment. There's 2 sources. And if it's a fee for purposes of the penalty assessment, it's a fee, right? There's no real distinction between the two. And if it's a fine, it is per se a violation of the excessive fines clause under both the state and federal constitutions. The excessive fines clause requires that fines be proportionate to the offense and to an individual's financial circumstances. The restitution fine is not proportionate to the offense because it's imposed on everyone convicted of a misdemeanor and felony, regardless of whether there is a victim in that offense. So that proportionality is missing. And it's not proportionate to an individual's economic circumstances, and in fact can't be, because the statute does not allow a judge to waive or reduce that restitution fine because a defendant does not have an ability to pay it. What Washington State did, which was simply eliminate their restitution fee, is precisely what I hope this committee will recommend the California legislature does. Finally, with respect to the use of the justice system to raise revenue, we cited several provisions of the government code that also impose various fees. I know this is not the committee on the revision of the government code, and God bless anyone who wants to serve on that committee. But the government code fees that we refer to are imposed through the penal code. They can only be imposed if someone is convicted of a penal code offense. And so I hope that you all will consider that within your purview when you make recommendations. And finally, let me just say about fines. Fines have been with us for centuries. They historically were imposed as an alternative to custody. Indeed, the first fines were a way to quite literally pay your way out of a feudal lord's dungeon. Today, they are imposed often in addition to a term of custody. And again, the question is, why are we doing that? What's the peniological purpose? What's our goal in punishing someone both with custody and with a financial sanction? And I will underscore that for people who are serving terms in prison, where it's by definition longer than at least a year, and I know in California, some of those sentences are also today being served in jail, but when we put someone in custody for that length of time, when they have a felony conviction, when we know that they're, as Representative Simmons talked about, their ability to earn is extremely limited. What's the benefit of having that fine in addition to taking away the thing that we value most, which is our liberty? If a fine is imposed, it should only be imposed after a judge determines that the defendant has a present ability to pay the amount imposed, and that ability to pay assessment has to be done with uniform and consistent standards. As a former judge, I can tell you that sometimes judges' discretion needs to be cabined. And in this area in particular, the judges are often using their own experiences and their own frames of references for determining whether someone has an ability to pay. And they're often looking at things that both we and the United States Department of Justice in its recent communication with courts across the country emphasized were really inappropriate. So how, for example, someone spends their money as opposed to how much money they actually have. And finally, mandatory minimum fines, again, violate the excessive fines clause. And that's because a judge has no discretion to weigh proportionality at all. And so for all those reasons, we think that mandatory minimum fines should be eliminated. And let me just, in response to Assemblymember Bryan's earlier question about states that about discharging debt. There are some states that by statute discharge debt after a fixed number of years. Nevada, for example, essentially discharges all traffic debt in particular, but after 10 years. So there is an ability to say at some point, this is just not collectible.
All right, I want to jump in here just to keep us moving. I do think we're going to want to get to specific examples, and especially things that I think what's been helpful to us just in general are examples from other states that you think might be useful to adopt in California. Last but not least, we have Mr. Dixon. from the Legal Services in Northern California. Mr. Dixon, welcome. 5 minutes starts now.
Thank you. So again, I'm with Legal Services of Northern California. I'm an attorney there, and we are a nonprofit law firm that provides free legal assistance to empower our communities to identify and defeat the causes and effects of poverty. And part of how we do this is through providing assistance with expungement and dealing with court debt post conviction. And so we do lots of things, but as related to this committee's focus, this is one of the things that we do. And we also do this in conjunction with Debt Free Justice California, or DFJC. And some of the work that it does. And DFJC is a statewide coalition that was formed in 2018 and is dedicated to ending the ways in which wealth is systematically extracted from low-income and minority communities. And I should mention that DFJC is composed of various organizations with different areas of focus, and some organizations like Legal Services of Northern California engage in some, but not all aspects of DFJC's work. Now, I appreciate Representative Simmons' story. I think it's great to be able to hear that. And I'd like to also speak to the ways in which many legal aid attorneys see how fines and fees are impacting our clients, with some emphasis on the expungement context. Because one fee that we see frequently is the fee that's charged for processing an expungement petition. And we have clients who pursue expungement to gain housing, a professional license, employment, advancement with a job, or even to be able to volunteer. And we'll even get clients who come to us after being offered a job on the condition that they obtain expungement. And the Penal Code actually allows expungement petitioners to be charged for a fee to cover the actual costs, and I emphasize the word actual costs related to processing an expungement petition. This fee can be up to $150, and those courts who charge the fee for each petition that's filed. So if I have 5 petitions, and I file them all at once, I can be charged up to $750. This is despite the fact that the petitions will likely be heard all at the same time. And so whether or not there's really any additional charge for each of those petitions is probably up for debate. And so I have had clients, due to these costs, decide not to file their petitions out of fear that they would be stuck with this debt regardless of whether or not their petitions are granted, which is the case. You are stuck with this debt regardless of whether or not your petition is granted. And I've also had clients decide to file petitions 1 or 2 at a time in order to manage the costs. However, that can further delay a person's ability to pursue employment, or it could cause them to lose a pending job offer. And AB or Assembly Bill 1803 now requires the use of the fee waiver eligibility requirements used in Government Code Section 68632, which is used in many civil cases. This makes a person automatically eligible for a fee waiver if they receive certain government benefits or have income at or below 200% of the federal poverty level. Now, 200% of the federal poverty level happens to be one of the income thresholds for receiving free legal aid. And as someone who must inform people that they are ineligible to receive free legal aid because they're over this income limit, I can tell you that there are people who are over 200% of the federal poverty level who can't even afford to pay rent. And so that 200% limit doesn't really help some folks that we're assisting. And so there are, or some folks who are coming to us for assistance. There is a third category of eligibility that requires a fee waiver to be granted if a court determines the petitioner cannot pay the fee without using money that would normally pay for basic household needs. However, we've seen people who were on government benefits and experiencing homelessness who were determined to be able to pay the fee, and their fee waiver was denied. And so this fee, especially when applied to multiple petitions, has been a barrier for many people trying to work and get out of poverty. And unfortunately, unlike the civil context, there is no explicit right to a hearing in the penal code to challenge a fee waiver that's been denied. Now, I want to quickly, with the time I have remaining, talk about the impact that general legally imposed debts are having on our clients. Now, the outstanding fees and fines assessed in relation to a court case are often used as a basis to deny an expungement petition. And although the expungement statutes were recently amended to prohibit the use of restitution or restitution and fine as a basis for denying an expungement petition, there are plenty of other fines and fees related to a case. And I've seen petitions denied simply on the basis that there were outstanding fines and fees. And we make arguments that a petition should not be denied on these bases. However, any given judge may or may not accept those arguments. And last, I want to point out that, in addition to legal debt making it difficult for our clients to gain an expungement that could lead to housing and employment, the debt creates a real financial burden that makes it difficult to cover basic needs. And I'll show you this through a quick story. We have a client who had a job lined up. He was going to use his tax return to get his car fixed, and so he could use it for work. However, he experienced a tax interception to collect on outstanding restitution. And so with that tax return gone, he was not able to get his car fixed and he lost the job. So, and we have lots of clients with high legal debt balances and no prospects of being able to pay. And part of the reason they can't pay is because they can't get employment. So that this debt is just hanging over them. And when they start to get money, they get tax intercepts or they have to pay, making it harder to get out of poverty. Thank you.
Thank you. I think that is also a common theme that we hear a lot, is about how things that are intending to improve public safety and improve public benefit end up being downward spirals and only making the situation worse. So I was very glad to hear from everybody on the panel. And I do think that there is some consensus. Aside from, let me start here. Perhaps I'll start with Judge Foster. Does it make sense to separate traffic fines, fees, however we want to call them, from the rest of the kinds of court-ordered criminal fines and fees that we've been talking about today? Is that a logical distinction?
Not in my mind. So in both personally and organizationally, we believe all fees should be eliminated. We think they're taxes. We think they're highly regressive taxes. And we think government should be paid for, particularly the justice system, from general revenue. So, and we think that applies to traffic as well as to felonies and misdemeanors. And we think fines should be proportionate. And they should be proportionate whether it's a traffic ticket or it's a felony. And as I said, we also think in the context of felonies and misdemeanors, if there's a term of custody, there shouldn't be a fine. You don't have that issue with traffic. And I do think that we're very familiar with the My Citations program. I am in particular. Before I founded my organization, I was in the Justice Department and we provided a grant to California to develop My Citations. One of the issues is the standards that are used are, like Mr. Dixon indicated, tied to the federal poverty level. In our view, that's just an inappropriate standard because first off, it's a cliff, right? You either are above or below.
I understand that's imperfect. I just,
But no, we don't, I don't think there's any distinction between traffic misdemeanors and felonies. I will say the volume is in traffic. And what we do see is traffic, because particularly the fees in California are so high. I mean, $390 on a $100 fine is, and leading to an almost $500 citation. And traffic is volume, right? The number of people cited for traffic offenses swamps the number of people who are charged with misdemeanor and felony offenses. And so it leads people into the system because they can't afford to pay the fines and fees that are imposed.
I appreciate that. Representative Simmons, though, it seems like in Washington, I don't know if it's just always traditionally been this way, or if you guys made a conscious distinction to distinguish between traffic fines, violations, and the court order or the criminal, other criminal types of fines and fees. So wondering how, if you made that distinction, was that distinction exist before you and you just took advantage of it, or you understand what I'm grappling with here?
Yeah, that distinction was definitely present before I started doing advocacy on this issue, but we did at least make a law where you can't suspend someone's license for inability to pay one of the fines for like speeding or something like that. So we've done that. We still have work to do around the use of collection agencies, for example. I definitely want to tackle that. I mean, I would love to eliminate fines also for, you know, speeding and stuff, but we'd have to figure out, you know, what would be the punishment then. You know, I like the idea of what they do in Europe is a day fine. So it's basically, you know, what is your wage for the day? So it's proportionate at least, you know. So we still have a lot of progress to make here.
Chair Romano, one thing that's important to note is that many states don't impose fees on traffic citations.
Okay, so let's disaggregate this. So they have a traffic citation, which is money.
Right, fine.
Fine. But then you're saying they don't pay a fee on top of the fine. Right.
So California, the assessments are imposed on everything, right? Misdemeanor traffic and felonies. But Washington, D.C., where I currently live, if you get a speeding ticket, there's just a fine. There are no fees that are imposed at all. They impose some fees on misdemeanors and felonies. They don't impose them on traffic citations. Every state is different in the way that it constructs its systems. And many states, California is an outlier in even having traffic as a criminal offense. The vast majority of states, it's a civil citation.
Well, you know how we care about our cars.
I do.
So yeah, I mean, for better or worse. Is there a state, and perhaps it's Washington, in your eyes, Ms. Judge Foster, that really has got this as close to right as possible?
Well, Washington by no means has it close to right, believe me. But no, there is this phenomenon is everywhere, and I will say,
is there a state that? So you're saying California is an outlier? Is there a state that's at least in the best position that we should maybe look to in any respect? I mean, you're going to look to
that's hard to say. So let me just say two things. California has made a remarkable amount of progress. When I talk to people around the country, I cite California both as a good example and a bad example. So the good side is California's eliminated thanks to debt-free justice, California. They have been phenomenal advocates and eliminated many of the fees that are imposed in the criminal justice system. They're just imposed either before or after conviction. So California no longer charges public defender fees. You don't charge electronic monitoring fees. You don't charge probation fees. That's good. Many other places do.
No, I understand.
California's fees at conviction are among the highest in the country. In fact, I'm not sure I know of any place, with the exception of the state of Iowa, which charges counsel fees by the hour. And so they can potentially accumulate to be very high. So Washington State actually is a model in many respects, and its most recent legislation. So many states allow judges, for example, to do ability to pay assessments.
And how could it be better than what we were talking about before, where if you have a public defender, you have no fines or fees, period, for criminal cases?
Oh, so New Mexico just eliminated all of its fees at conviction, like literally this past legislative session, all of them.
So period, regardless of ability to pay, regardless of it.
Regardless, what most people, well, two things. One is the vast majority of people in the system qualify for the services of a public defender.
No, that's why I was asking.
And also,
so can I just stop you before you go?
Yeah.
Because I am curious about it. I mean, the problem with eliminating fines and fees, period, so to me, it seems like, well, what if you have a big company that's polluting the water and you want to be able to?
No. And so we do not advocate eliminating fines. We do think that there is, that you, as Representative Simmons just said, there has to be a punishment for an offense, regardless of what you think is. And I hope you all are looking at whether something should be criminal. That's a whole other question. Not only because I'm a retired judge, but our organization generally believes in the rule of law. If something is illegal, there has to be a sanction for people who violate the law. And a fine can often be the appropriate sanction if it's proportionate. If someone a big corporation gets a big fine, they can afford it.
We understand that. Just to clarify, Ms. Representative Simmons, is it fines and fees if you have a public defender totally?
Yeah, we don't give fines here generally. Yeah, I don't think we can give fines if you have no inability to pay.
So just to clarify, because
criminal LFOs.
I don't want to play with words.
Yeah.
You owe no. You're convicted of a crime in Washington State, and you have a public defender. You owe no money to anybody. Nope,
not anymore. We eliminated the last two mandatory. So before that, they do an ability to pay assessment, right? But if you have a public defender, then you meet the threshold for the ability to pay.
Then you automatically qualify.
And so we have no more mandatory.
And there's no discretion. A judge can't order it even if they want to for somebody if they have a public defender.
If they did, then we could appeal, because if they did not have the ability to pay, we have case law under Wakefield that says that the judge cannot impose fines and fees on people who have no ability to pay.
Got it. Interesting. Do others have questions?
I have just an observation.
Yes.
I was on the old municipal court. In lieu of a fine, you could either do like 13 days of Caltrans service or 13 days of county jail, or a certain amount of community service, some proportionate amount. And this was in the Compton Judicial District, which was generally low income, and many people couldn't pay a fine. But in terms of a penalty, in lieu of a fine, we would impose those kinds of alternative sentences as a way of paying the fine indirectly. So I wonder if that's something that is very common in the states that we're talking about, or how often that is used really here in California.
Yeah, in our first bill here in Washington in 2018, when I was an advocate that we passed, we created a community service alternative. But what I advocated not to have that in the last bill, because, people, this is most of the time, it's a vulnerable population that is very poor and just has so many things that they're contending with. It's hard to pay for childcare to get there to do your community service or get transportation. And it was just like, why are we fighting so hard over this very small amount of money that's actually collected? And when you get the research and the data, you'll see that clerks are spending so much effort and time and postage to try and collect from this population of people who are in the criminal legal system and not getting much return. And so then to try and have them enforce community service, they have to call them back to court to see if they're compliant with their community service. It's just so much. Just get rid of it and fund the justice system. I mean, we're paying for it other ways, so the state needs to come in and just relieve the counties and the cities from having to collect revenue this way and fund the justice system.
Yeah, I agree with all of those observations. I think that's what would happen. It was just another way of just prolonging the agony of satisfying those requirements. One other thing that would occur because we had jail overcrowding, and there were instances of early release. Someone might opt to not pay the fine, which, let's say in the DUI case was $390. They would say, well, give me the 13 days in jail. And they would probably spend a day in jail and get credit for the 13. And they would make that mental calculation as a way of not having to pay a fine of $390 with penalty assessments, which would come up to about $1,000. So in their mind, well, they would rather do a day or two in jail, get early released, and not be obligated to pay a fine and penalty assessments.
Yeah.
Justice Moreno, I'll share with Rick. There's
Wait, if I might, Judge Foster, I just want to try to observe Zoom etiquette as we're at the end.
Sorry.
No, it's quite all right. I think Mr. Dixon and then Professor Sykes, and then Ms. Foster, Judge Foster.
Yes, I do appreciate Representative Simmons' comment about community service. We've seen quite a bit where clients are asking for an ability to pay determination and being told that their only option is community service, not a reduction, not a waiver, but only community service, which for the reasons that Representative Simmons mentioned, does not work for everyone and could actually make the situation worse. And in addition to that, they're being required to go to the sheriff's office to do the community service through there, and then they also have to pay a fee to do community service. And so I just mentioned to you that I don't have the ability to pay this fee, but I, for some reason, have the ability to pay for community service.
No, that sounds ridiculous. Professor Sykes.
Yeah, I was just about to underscore the very same point that Mr. Dixon just made. In my current research study in California on a field experiment whereby we randomly assign people to treatment and control groups to pay for their rehabilitation courses, a number of people have also been sentenced to complete these community service programs that are offered through private providers. And having seen those bills, having paid those bills are very expensive in terms of not just their rehabilitation costs, but also this community service that people believe is largely free.
Yeah. Judge Foster and then Representative Simmons, and then we're going to try to wrap it up here.
Yeah, I was just going to say there's a very good article that Professor Zatz at UCLA did about community service in Los Angeles County, and I will send the link to Rick. So if you all are interested.
That's super helpful. Thank you. Representative Simmons.
Yeah, I just wanted to say, if you all do something, I'd love to help you, but also make sure it's retroactive. So that's one thing I'm so happy about is that, before we passed this last bill, I would go around the state, hold these huge days and everybody loved it. Judges, prosecutors were crying. They loved it. People came in off the streets and we eliminated as much as we could, but we could never eliminate the last two mandatories. And now, we have, so in my day job, the nonprofit I founded, we do individual representation, and we have hundreds of thousands of people we have to help because now everybody can go back and get the rest of it taken off. And then a lot of times, depending upon their offense, they're eligible to vacate their criminal history. And what that means is that they're opened up to job and employment opportunities and volunteering in their kids' schools and really feeling like they're part of the community again. So anyway, I just think that whatever you do, make sure it's retroactive.
No, I think the retroactivity point is a good one and something that we've talked about before in other contexts. And, it just doesn't seem like why any reform should not, all reform should be retroactive. It's good today. It should be good yesterday. My feeling. From the committee members or staff, are there any additional last questions for this panel? All right. Thank you all so much. As I say almost every time, we couldn't do this work without you. I really do appreciate it. We will be back in touch, I am sure, to pick your brain. Please be back in touch with us if there are things that you think that we would, the article you mentioned, Judge Foster, Representative Simmons, we will take you up on it. You will now represent both your old home and your current home. We'll recruit you with my magic wand. Thank you so much. I'd like to take a 10-minute break. So let's reconvene at 3:05, and we'll take up the rest of the committee business for today. Thank you all. 3:05.